I've been asked what is the shortest insolvency case I've dealt with, and probably the true answer to that is that there's been a lot of cases over the years that have been very short, but they tend to be cases where either a company or an individual has a number of debts but is in the fortunate position of there being a third party who will be prepared, following creditors' agreement, that a full and final settlement can be agreed, to introduce a lump sum either into the company or to the individual to allow a once and for all settlement. This is normally achieved either through an individual voluntary arrangement or a company voluntary arrangement, whereby 75% in value of creditors who are asked to consider the proposal need to say yes for it to become binding. But in those circumstances, it is in theory possible for the lump sum to be offered at a meeting of creditors, for the appropriate approval to be given by creditors, and for, in effect, the third-party money to immediately be paid to the insolvency practitioner within days, and then subject to the insolvency practitioner agreeing the claims against the company or the individual and being happy that they are valid claims, usually working in tandem with the directors or the individual themselves. Then the agreed payment, be it 20p in the pound, 50p in the pound, or whatever has been agreed by the creditors, can again be made within days and the insolvency concluded very quickly. The insolvency in those circumstances would usually be concluded by a simple final report to the creditors explaining that the third-party money that they were offered has been received, it's been paid out in the appropriate proportions, and the matter closed. Hence, an insolvency that can be concluded literally within a matter of days and weeks. Alternatively, insolvency practitioners also do in fact deal with solvent liquidation, and that can quite often be in circumstances where a company has been used to carry out one specific project, and perhaps the directors are looking to release the funds that have been generated by that project. In these circumstances, the meetings of the board and shareholders, which are required to wind up the company and then allow a liquidator to make a distribution of the funds to the shareholders, can literally take place on the same day, so that within the same afternoon even, a board meeting and the necessary meeting of shareholders can take place, and then as soon as the necessary funds are paid to the liquidator can then distribute the excess funds, assuming all other debts have been paid, to the shareholders with immediate effect. This can result in the winding up of the affairs of a company and the distribution of its assets, again literally within days. However, it should be noted that for speed, if directors wish to receive such a distribution in very short terms, it is usual for a liquidator to request an indemnity or guarantee from the shareholder directors that they will reimburse the liquidator if an unknown liability comes to light after funds have been distributed to the shareholders.